This is The Law Show on CL 650. Now back to the show.
Welcome back to The Law Show, our final segment with John Lakes and John White from Lakes White LLP in North Vancouver. We're talking estate planning and estate litigation, and we've been focusing a lot this morning on spouses and their standing and definition in law, their rights in law, and, a couple of cases that John White has brought to the program today involving decisions by the Supreme Court of British Columbia as to exactly who was and who wasn't married in a common law scenario. And both cases, John Lakes, you said, there was no will. So the court was pretty much left on its own to decide. But there is a formula in British Columbia. We have, under this new Wills Estates Succession Act, or WESA, we have a provision for people in British Columbia who die without a will. What happens to a BC person who dies without a will?
Right. Well, it's called administration, and it's changed quite a bit in 2014. But if someone dies without a will, with just a spouse and no children, then the spouse receives everything. If they die with a spouse and children, what happens if the children are from the relationship of the deceased and the spouse, then the spouse gets the first $300,000, and then she would get one half of whatever's left, and the children would get the other half. If it's a second marriage, so the spouse is a different spouse than the
children's mother.
So basically, what happens is the spouse would get the first $150,000, and then it would be divided between the spouse and the children of the first marriage. So, and the other thing that's a significant change is under the old act, the spouse also had a life tenancy of the spousal home,
the ability to live there for the rest of
their
her
life.
days, right?
And it did create a certain degree of uncertainty when you got into costs. So that's been changed, where basically what happens if a deceased person has a spousal home, then the surviving spouse has the right to exercise to purchase the spousal home 180 days after the probate's been issued. And there's a whole formula about how you calculate the valuation and everything else. So the problem you have is someone dies, and they have a will, and the spouse can't decide whether or not they wish to acquire the house. Then things are frozen for 180 days thereafter.
I see.
So,
okay.
But those rights are only given to the spouse, and if you're married, you're fine. But if you're common law, you still have to prove you're the spouse.
Right.
And that's where we keep going back to the issue that a common law spouse does not have the security that a married spouse has.
And so, John White, if you're in a somewhat precarious relationship, a common law relationship in which perhaps all isn't as harmonious as you would like it to be, and you are concerned about your future and being written out of someone's will, then you need to start doing things like accumulating evidence, should it ever become necessary, to prove that this was indeed the sort of marriage or relationship, at least, that the courts recognize as common law.
Yeah, that's fair enough. I mean, if your concern is being written out of an existing will, at the end of the day, the will maker can write you out of the will if he or she wishes to.
Right.
And you might have rights under our wills variation legislation, which is also part of WESA. And so you'd be proving that you're a spouse that way. Or, as the example John was talking about, where your spouse, quote unquote, dies without a will, then you've got a different reason for having to prove that you're a spouse. But at the end of the day, there are rights that go with being a spouse, which you just don't have if you're not a spouse. And
right.
Those last two cases we looked at turned on that very question, because the consequence for not being a spouse is that the parties in question would have had no rights, and indeed that's what happened to one of them.
Interesting. John Lakes, not a lot of time left, but income tax returns are a big deal for you in this regard. Why?
Well, because if you declare yourself as a spouse and your partner says a spouse on the tax return, you've got some evidence there.
And the feds have accepted it, and that's
but
that.
The problem lies is sometimes people want to pick and choose when they're a spouse and not a spouse. And if you filed income tax returns every year showing yourself as a single person, then that will be used as an evidence against you if someone's trying to challenge you common law, and they say, well, you're just a girlfriend and you don't want to lose your husband's pension from the first marriage. So you're either in or you're out. You can't be sort of pick and choose your common law when it suits you.
Is there ever a case, we've got literally 60 seconds, is there a case, this is a popular myth that I'm sure you're both familiar with, you die without a will, you're single, no dependents, does the government get it all?
No.
I mean, there's a whole laundry list of rules that govern what happens if you're a spouse, or if you're a spouse with descendants, or if you die where you're not married, you don't have a spouse, you don't have any descendants,
right.
And there's just a whole series of levels, a series of rules, if you like, by which the court determines where your property goes. But it doesn't all default to the government if you just don't have a spouse or kids.
Well, thank you for bursting that myth bubble, because that one, I believe, is still widely held. John Lakes and John White, always a pleasure, gentlemen. Good to have you come by this morning. Great to see you. Enjoyed the conversation about spouses a lot. We'll talk about kids, children, and their legal status when we return with you next time on The Law Show here on CIL 650.